Hello, everyone. I'm Justin Silverman with the New England First Amendment Coalition. Thank you for joining us for this latest open government lesson. For those joining us for the first time, welcome. These lessons are a part of a growing NEFAC library of classes on public records, open meetings, court access, and our right to record. All lessons are available to view in our FOI guide or on our YouTube channel, Five Freedoms. To everyone, please take a moment to subscribe to NEFAC's community newsletter. This is the best way to stay informed about upcoming classes and events. Just go to nefac.org/subscribe. Today's presentation is supported in part by the estate of Gloria L. Negri. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other NEFAC supporters at nefac.org/supporters. During today's presentation, I again encourage you to introduce yourself in the chat and share your own experiences and resources. You can also use the chat or the Q&A button to ask questions of our instructor, and we'll get to as many of those questions as possible. Let's get started. Here's Harrison Stark, NEFAC board member and staff attorney at the ACLU of Vermont. Harry, all yours.
Thanks so much, Justin, and thank you all for being here. Excited to chat with you all today about the right to record here in Vermont. Again, I'm Harrison Stark, he, him pronouns. I'm a senior staff attorney at the ACLU, and let's just get right into it. So today we're going to talk about really three umbrellas of the right to record. One is the right to record government officials themselves, including at public meetings or when they are conducting official business. We're also going to talk about the right to record court proceedings, including the various kinds of restrictions or limitations, depending on the kind of court. And third and finally, we're going to talk about the right to record or photograph public records. So this is your ability as a journalist, as a citizen, to use your own equipment to photograph public records when you're viewing them either in person or electronically. Let's get started. So, somewhat surprisingly, the law is technically unsettled in some ways on the right to record government officials. But based on what other courts have said outside of Vermont, the weight of authority is heavily in favor of your right to record government officials conducting official business, essentially whatever the context is. And so I want to be clear that when we're talking about what the law is here, we're essentially triangulating because neither the Vermont nor the Second Circuit nor the US Supreme Court has issued an opinion on this that binds Vermont in an authoritative way that entirely controls. But if you're ever in a situation in which your right to record government officials is contested, here is the law you turn to. And again, the law that does exist, the persuasive authority that exists, is heavily in favor of your right to record. That's true under the First Amendment to the US Constitution. It's also true under the Vermont Constitution. So, as I mentioned, neither the Vermont Supreme Court nor the Second Circuit Court of Appeals, which is the United States Appellate Court, which governs Vermont, neither one has addressed whether there's a right to film government officials. But other federal appellate courts have recognized a First Amendment right to record police personnel carrying out their official duties. They said that that right is clearly established in a way that the government cannot violate it without being liable to individuals. And the logic of those opinions applies to public officials generally. And that makes sense. If you have a First Amendment right to record police officers or other government officials in public places exercising public power, that's true regardless of what the context is. And because of the key First Amendment principles of holding government officials accountable, including the public's right to know and right to disseminate information about what the government is up to, all of that authority points very heavily towards your right to record public officials regardless of what they're doing when they're exercising public power. That's true under the First Amendment. There's also additional authority that is Vermont specific that makes this an even stronger case here in Vermont. As many of you know from some of our earlier sessions, there are multiple provisions of the Vermont Constitution that are unique and stronger in some ways than our federal counterpart. And so, in addition to our First Amendment analog in the Vermont Constitution, which is Article 13, we have Article 6, which states explicitly that all power being originally inherent in and consequently derived from the people, all officers of government, whether legislative or executive, are their trustees and servants, and at all times, in a legal way, accountable to them. And so there's this additional backdrop in Vermont about constant legal accountability to the people when government officials are exercising their public power. That, again, is an additional consideration that weighs heavily in favor of your right to record and disseminate information about public officials when they are conducting official business. Also, although there is no Vermont Supreme Court opinion directly on point, it can be helpful in situations in which the law is unsettled to point to things that the legislature has recognized or not. And if we look at statutory limitations to crimes like voyeurism that are in the Vermont Code, we see that the legislature has explicitly recognized that there are First Amendment and other constitutional backstops, essentially. So, although voyeurism is generally a crime, it explicitly says in the statute, this does not apply to when you are recording or looking at or viewing public officials like police officers. The First Amendment still comes into play. Those kinds of statutory recognitions are just another point of support in establishing that the best reading of the law as it applies in Vermont is that you have an incredibly strong right to record public officials conducting official business. This context is, we talked about police a little bit, and folks kind of exercising public power more broadly. These considerations are really at their apex when it comes to public meetings and the open conducting of official business. Again, Vermont's open meeting law, which we've talked about in prior sessions, exists to explicitly effectuate that constitutional right that we were just talking about under Article 6. And really says in the text of the statute that although this is a statutory authority, it really is underpinned by constitutional considerations. And it says that explicitly in the statute. It's also important what official bodies of the state have themselves said about understanding the statute. And so the Secretary of the State here in Vermont has published guidance that understands the OML to permit members of the public to record or film public meetings. And so again, the fact that that has come from the Secretary of State is an additional consideration. One final point about open meeting law that I think is really important, particularly today, is that as we talked about in an earlier session about new hybrid requirements under the open meeting law, there are now explicit statutory instructions that, where possible, many Vermont public bodies have to take steps to create hybrid or remote access, including at times by recording or transmitting streams of official business. And it's really important to note that those recent statutory changes that increased hybrid access in no way affected any of these rights, which belong to you as an individual holding the government accountable. And so just because the law now requires the government to increase access by, for example, streaming public proceedings, that in no way infringes on or limits your own right as a citizen to record government officials. And so these two things are unrelated. And we've seen some confusion about this with some public bodies in Vermont that say, well, because we're recording this and transmitting it, in some way that maybe limits the public's right to record. And that's simply not the case. These are parallel obligations, and nothing about increasing access through hybrid requirements infringes on, limits, or affects your right as a member of the public to record government officials, which, as again, stems from the First Amendment and stems from the Vermont Constitution. Next, we want to talk about a particular branch of government. I want to talk about the right to record court proceedings. And although there is a public right of access to court proceedings, as we've talked about, because of the potential for disruption when it comes to individuals recording or transmitting live proceedings of the court, the rules are somewhat more limited. And I want to be clear that today we are talking about a kind of broad overview of how to understand what your right to record in court proceedings looks like at a very high level. But the rules themselves are very specific and would take a lot longer to get into than we have time to discuss today. And so this slide here, pause your YouTube, take a screenshot. If you are ever looking for the specific rules that govern your right to record or your right to broadcast, look up the specific rules that apply to whatever court proceeding you want to access. And again, here are the rules for the criminal division, for the civil division, for the family division, and for the Supreme Court. And again, they all differ. So please bookmark this page, and I would encourage you, in addition to watching this video, to look up the specifics of any of these rules. Really generally, though, let's talk about kind of what your baseline expectations should be. Generally, in a courthouse, the public building of a courthouse, anyone can possess an electronic device. And you can record, photograph in public places. What you are not allowed to do as a non-member of the media is to use devices to record or transmit images or sound of another person without their consent. And I should pause here to say that there are distinctions laid out in these rules, and this is true for all of the courts, that differentiate between members of the public and registered media organizations or registered journalists. And today's session is really geared towards what your rights are and your obligations are as a member of the general public. If you are a journalist or a member of the media, there's a comprehensive set of policies that will get you on the list of registered individuals. And once you're a registered member of the media, you have additional flexibility, additional rights that enable you to disseminate public information about the court proceedings. And again, here are some of the general considerations if you are a member of the media and you're in a courthouse. The rules are slightly different when you move from the halls of the courthouse into an active proceeding in the courtroom. In general, members of the public are not typically allowed to use devices to communicate orally, that is, to sort of take a call or anything like that, or to record or transmit audio or video in a courtroom. If you are a member of a media organization that's registered, you may record using devices, you may live stream, but you are not allowed to record audio of bench conferences, discussion between the lawyers, or activity during a recess. The idea is that you're only supposed to be transmitting kind of the official proceedings on the record. You're also not allowed under the rules to record any audio or any video of attorneys discussing anything that's happening with their client. You're only allowed to take still photographs for that. And the idea here is that there is a tension or a balance in some ways between your First Amendment, common law, constitutional rights to access official proceedings, and also the obligations of attorneys to provide full, unencumbered, diligent counsel to their clients. And so it's balancing the attorney-client relationship and the kind of smooth, confidential aspects of court proceedings with the public's right to access court proceedings under the First Amendment and the Vermont Constitution. And something that comes up in a lot of these rules is that there may be requests to essentially pool transmission. So that is, if one media organization is broadcasting it, they may need to share in some way, as opposed to having multiple streams set up. Something that is important to note is that all of these rules are essentially baseline presumptions, and that in any particular proceeding, the court retains discretion at virtually all times to alter the arrangements based on a host of factors. These factors include the impact of recording or transmitting on the proceedings themselves, whether there is particularly private or confidential information that would be revealed during the testimony, whether there could be witness intimidation, or particular characteristics of whoever is speaking or testifying. And this goes in both directions. And so, if there is a event where the court might be inclined to limit media access, you can ask the court to alter that to increase access. Similarly, if there is an event or a hearing which might presumptively be open to the public, sorry, not open to the public, presumptively recorded or transmitted to folks beyond just those in the courtroom, the court can also alter that based on the host of factors. And under the rules, the anyone can request a change in the arrangements, and the court is supposed to hold a prompt hearing if that order is sought. And the idea is that the person asking for a court order to change the status quo bears the burden of showing that that change is necessary. But just another caveat to say that these are essentially starting presumptions. They're a status quo that the rules set that are always under the rules up to the individual judge or the court to alter and balance in order to try to properly serve at all times both the rights of the litigants and the jury and the right of the public to fully access the proceedings. The rules are similar but slightly different in our Supreme Court. The key difference is that in the Supreme Court, non-participants, that is folks who are not litigants, you may use your device to record or transmit audio or video. The considerations for registered media are largely the same, although of course, because there are no jury trials, some of the considerations about the jury pool in particular are just not applicable to the Supreme Court. Third, I want to talk today about your right to record through a photograph or through a screenshot public records or other documents. And I think this is probably the most unsettled question that we're going to confront today, in that there is a dispute here in Vermont about what government agencies can ask you to do if you want to photograph or screenshot public documents. The rule is that you can always do it. There is nothing that prevents you from pulling out your phone, taking a screenshot, using whatever device you want to photograph a public record that you're inspecting. The question is whether or not the agency is allowed to ask you to pay in order to do that. I want to be clear, this is an unsettled question. Nothing in this video should be construed as legal advice, but it is my personal opinion that the weight of authority, again, is heavily in favor of your right to photograph public records free of charge. What is this dispute actually about? It comes down largely to how to interpret a 2019 case that, full disclosure, the ACLU of Vermont litigated, which was about whether or not agencies could charge costs for anyone who wanted to inspect records. And again, we've talked about this in prior videos. Under the Vermont Public Records Act, there are two rights you have as a member of the public. You have a right to inspect, and you separately have a right to copy or kind of take home or retain records. And what the Supreme Court said in this case is that the statute talks about charging compensation for staff time associated with copying, but it doesn't say anything about charging staff time for inspection. And so under the Act, agencies cannot charge any money at all for you to inspect records under the Public Records Act. And the opinion really highlights this key and sharp distinction of the statute, which is backed up in the statutory text, between your right of inspection and your right of copying. In the wake of this opinion, there was a split in Vermont government over whether this opinion prohibited agencies from charging the copying costs if you wanted to do the copying yourself through a screenshot or through a photograph. The prior Attorney General, TJ Donovan, took the position that nothing in the opinion or nothing in the Act prohibits an agency from wanting to charge you for any kind of copying regardless of whether you were the one doing the copying through your screenshot or through your photograph, versus whether or not the agency was the one making copies for you. The Secretary of State and the Scott administration, our governor's office, disagreed and released guidance saying, under this opinion, the logic suggests that the only reason an agency should be able to charge money is if their staff is basically sacrificing their time and capacity as public servants in order to make copies for the requester in some way. But where you're the one doing the work, you're the one screenshotting, you're the one taking a photograph, you're the one taking a screenshot, there's no basis for the agency to charge any money for that because it doesn't cost them anything to make the copy. Again, there is no direct authority on this. The best reading, in my opinion, of the Doyle opinion aligns with the governor's instructions that where the individual is the one making the copy through a photograph, through a screenshot, and the agency is essentially just providing the records for inspection, but no staff time is used to copy. The agency should not be charging the requester any money at all when the requester is the one making the copies. And so if you are in a position in which you inspect records, you want to take your own photographs, and the agency says, hey, wait a second, we can charge you for you making your own copies, I would direct you to the Scott administration's reasoning in their guidance that they put out in 2019, which instructed public agencies of the state, which again are just a subset of some of the institutions that are subject to the Public Records Act. And so the guidance doesn't bind every custodian in the state, but I would direct you to call upon that guidance, point to that reasoning and say, for all the reasons that the governor directed his agencies not to charge copies when you are the one making the copies, that should apply here too. And so that's a key resource that I would direct everyone to. And again, the guidance is about how to interpret this opinion, just cited here on the screen, Doyle versus the City of Burlington. And so worst comes to worst, I would also encourage you to print out the Supreme Court's opinion here and really draw attention to the fact that what the court is talking about is the ability of agencies to charge where their staff is the ones who are having to work to produce the copies, but that nothing in the opinion suggests that it makes any sense at all to charge a requester who is using their own time, their own resources to make the copies. And instead, the only obligation on the agency is to provide the records for inspection, which the opinion makes clear has to be done free of charge.
Great. Thanks so much, Harry. Appreciate it. A lot of really great information here. A couple questions before we wrap up. One, more broadly, a topic, if you could touch on it, the taking of photos and videos in public buildings, like going into a town hall, for example. Are there any circumstances or any areas that where there's an expectation of privacy that might prevent us from taking photos or video in public buildings?
It's a great question. And at the risk of giving the typical lawyerly response of it depends, it's a little bit of a contextual analysis. Again, we don't have anything that's clearly directly on point here in Vermont. In general, the same considerations that have gone into courts discussing the right to record government officials conducting official business in public places applies to government facilities that are open to the public. And so anywhere that you have a right of access to, the same First Amendment considerations should apply. It's obviously a little bit different if there is an expectation of privacy for particular government workers in a particular office. It's also a little bit different if you are recording members of the public who are in that space. Again, the precise expectations of privacy differ a little bit on what kind of forum you're in. And so, for example, someone speaking at a public meeting has a much lower, even if they're a private citizen, a much lower expectation of privacy than, if I am, say, going to town hall to drop off my property taxes, and I'm being photographed by somebody else, but I'm not a public official engaging in public business, but a private citizen who just sort of happens to be there in that capacity. It's a little bit different, but in general, any place that is open to the public, that the government has made available for the public conducting of business, like a town hall, your right of access is essentially, it mirrors your right to record or your right to document the conducting of official business under the First Amendment.
Thank you. Question regarding the open meeting law. You mentioned earlier in your presentation, Secretary of State issued some guidance saying that all members of the public are permitted to record or film public meetings. Does any announcement need to be made before that recording begins, or can you just go ahead and attend a meeting, camera out, and let it roll?
A great question. I am not, again, so long as you are in a public place where there is an expectation that anything you say is open to being documented as kind of part of the official business, or you're addressing government officials in public, your expectation of privacy as a private individual is diminished. And so I don't believe there's any legal obligation that I'm aware of that requires anyone to kind of announce in advance if they're a member of the public and they're recording the public officials who are there conducting business. I would say it is good form in general, just sort of with your fellow citizens, to tell people that they're being recorded. And so, often if you're on a Zoom call or a public meeting or a lecture, you'll see a notice, and one even just pops up here on Zoom that says, please be aware that there is a recording in process. That's often when there's a recording that's going to be taken or retained in some way, by an official institution, by the government in some way. All of us, though, have the right to record public officials. And I don't think that there's anything that requires you to announce to the public officials in some way, I'm recording this open meeting, I'm recording your kind of conducting official business. I think that expectation is baked into the open meeting law and into the First Amendment itself. Again, on the spectrum, things become considerably more nuanced. If you are recording or documenting in some way private citizens who are in the same space, not participating, not making public comment. But that's less of a First Amendment open meeting law constitutional consideration than it is kind of about your obligations vis-a-vis your fellow citizens. It's less of a constitutional problem, if that makes any sense.
Yeah, I think so. To summarize, even if you do have the right to record in those situations, good practice as a courtesy, let everyone know I'm recording, video's going, just give them a heads up is what you're suggesting.
Absolutely.
All right. Last question before we wrap up here, Harry. Thank you. You mentioned regarding our rights within the courtroom itself, you distinguished those in the media, those not in the media. You talked about the registered media. How does a journalist become registered to receive all the entitlements as a member of the registered media that other members of the public do not have? Yeah,
it's a great question. Without going into too much detail on it, there's essentially two routes. You can become registered for a particular event or a particular proceeding, or you can become permanently registered, in which case you're on an accredited list that you can bypass some of the procedural requirements. There is a step-by-step guide with the forms that is listed on the judiciary's website that I can provide, which I think would be great to kind of put in the description of this video when we put it online.
All right. Excellent. I will do that. You can look for a link with the show notes. Appreciate your time, Harry. A lot of really great stuff here. Very valuable guidance. Thank you. And many thanks to everyone who joined us today. We provide these lessons as a public service to you. So please return the favor and encourage your colleagues and friends to join us for future classes. Or better yet, consider making a donation or becoming a sustaining member at nefac.org/support. On behalf of NEFAC, thank you. Thank you for all you do, and we'll see you next time. Take care, everyone.